If I get a snake out and snake out my toilet to remove clogs, does that make me a plumber? It's questions like that that really give certain people problems because they want to think that the SCOTUS has ruled on something that the SCOTUS has not ruled on. Now, that said, I think everybody can be a plumber. You get out a plunger, you're plumbing, you're doing the work of a plumber. If you fix a pipe, you're doing the work of a plumber. But does it make you a plumber? I think that's where reasonable minds can reasonably disagree. Personally, I disagree with Mr. Wendell Fears. He says that just because you've got a cell phone that records and a YouTube channel does not make you news. It does not make you a journalist. It does not make you a member of the press. Well, by the same token, you can be a journalist, you can be a member of the press, and you can be a news reporter with a cell phone that records and a YouTube channel. A cell phone that records in a YouTube channel is a lot more technology than people had in the 1800s or the late 1700s. So I think there's more to the analysis personally, and I think there's levels of journalist, of media. I think there are levels of it. He says it just makes you an individual with a cell phone that has a record mode and a YouTube channel, unless you're using those to, I mean, you could be a pornographer with those, right? You could be a journalist with them. You can be a talk show host with them. There are a lot of different things that you could do with a cell phone that has a record mode and a YouTube channel. One thing I wouldn't say, however, because I'm not retarded, is that, gee, the SCOTUS disagrees with you. But let's look at what the retard has to say about the SCOTUS. The first case, he's not smart enough to figure this out, and I'm sure he'll prevaricate or obfuscate on why. I know why he did it. There are articles out there about the New York Times v. Sullivan and Abernathy v. Sullivan that say that, oh, you're a citizen journalist because Abernathy v. Sullivan was decided on exactly the same lines as New York Times v. Sullivan. I think they're wrong. That's not what the court said. But what the court did is it smashed together Abernathy v. Sullivan and New York Times, and it gave it all in one decision. And what the decision was is it doesn't matter who the speaker is. It matters who you're talking about in terms of libel. New York Times v. Sullivan is a libel case. So you have to look at it as a libel case. It's talking about libel. It's not talking about journalism, what makes someone a journalist. It doesn't care. New York Times v. Sullivan and Abernathy v. Sullivan, the court didn't care who the speaker was. It didn't even need to make that distinction. It just said it matters who you're talking about. If you're talking about a government employee, a government official, then the actual malice standard applies. Abernathy is a group of 4 clergymen who were listed as having signed on to an advertisement that was placed in the New York Times. Sullivan sued the New York Times, who was he sued them as a publisher, and he sued the people who were on the advertisement, who signed on to the advertisement. The court didn't draw any distinctions. It didn't have to. It said, look, Sullivan is a public official. If they're telling the truth, then they're fine. Or if they're not telling the truth, the actual malice standard applies, which means that they have to be reckless with regard to the truth or falsity, or they have to know it's not true in order for you to get your libel. That's all it holds. It doesn't say that citizens are journalists with no distinction. So that was, I don't know if you want to count that as strike one or strike one and strike two. You could do the math at home. You could figure it out for yourself. 50 years of jurisprudence is required to grasp the legal concepts. Wow. I mean, you're so smart. My God. How do you get through doorways with a brain as big as yours? How do you not know this stuff? I do know this stuff. You don't. That's the point. McGeorge doesn't teach these landmark cases. It certainly does. And this is where I started learning about them. See, you have to begin with libel. Oh, libel. No, see, libel is not the sum total of what defines someone as a journalist. In fact, libel does nothing to define anybody as a journalist because, as we just went over, it doesn't matter who the speaker is. It matters who is being spoken about. My dog is snoring really loud. So then he wants Near View, Minnesota, but don't bother. Well, no, let's bother. This is Near View, Minnesota. A Minnesota statute declares that one who engages in the business of regularly and customarily producing, publishing, etc., a malicious, scandalous, and defamatory newspaper, magazine, or other periodical is guilty of a nuisance. It doesn't say anything about citizens being journalists. Citizens can publish, absolutely. Citizens can do plumbing. It doesn't mean that everybody who publishes is a journalist, and it doesn't mean everybody who does plumbing is a plumber. It literally doesn't hold that. So, sorry. Then we go to Nebraska Press Association v. Stewart. Oh, was that strike two or strike three? I don't know. But Nebraska Press Association v. Stewart. The clue should be in the title. It's the Nebraska Press Association. Do you think that they're going to draw fine distinctions between the press and the not press? Obviously, no, they're not. The order prohibited everybody in attendance from releasing or authorizing the release for public dissemination in any form or manner whatsoever the testimony, any testimony given or evidence adduced. The order also required members of the press to observe the Nebraska Bar Press Guidelines. There is a distinction. This is dealing with an order which, as modified by the Nebraska Supreme Court, restrained who? It restrained petitioner newspapers, broadcasters, journalists, news media associations, and national newswire services from publishing or broadcasting accounts of confessions or admissions made by the accused to law enforcement officers, blah, blah, blah. Is this strike three or strike four? I don't know. You have to tell me. But he says that it's important because the SCOTUS pretty much declares everybody talking about something newsworthy is part of the free press. So just because you're talking about something newsworthy makes you a journalist? It doesn't hold that. It doesn't say that. It doesn't say that. It literally doesn't say that. If it doesn't declare it, not pretty much declare it, but if it doesn't declare it, it doesn't say it. And no. So everybody can be talking about something newsworthy, and that might be a part of the free press. Everybody might be replacing a pipe, but that doesn't make everybody a plumber. I know these are hard concepts for you to grasp, but Just deal with it. Roll with it. Then he has Chandler v. Florida. Chandler v. Florida builds off of Estes v. Texas. You don't have a Chandler v. Florida without an Estes v. Texas. Estes v. Texas says the due process clause requires you to not broadcast from the courtroom. Chandler v. Florida walked that one back. What Chandler v. Florida held is that as long as Florida is keeping things under control in the courtroom and being aware of the due process considerations, that broadcasters, television and radio broadcasters, and reporters, photographers can televise or broadcast radio signals or take photographs of the goings on inside of a courtroom. It's not a First Amendment case. It's a 10th Amendment case that walks back a Fifth Amendment case. It doesn't say anything about anybody having any rights to do anything except for Florida. Florida has the right to implement guidelines for televisation or radio broadcast or photography of its cases, of its criminal cases, as long as it keeps in mind the impact of the Fourth or the Fifth Amendment on those cases. That's it. It doesn't say citizens or journalists. Nowhere in here does it say citizens are journalists. Now, before we leave, that was the last Supreme Court case he cites, so he's failed. That was 4 Supreme Court cases, so that was strike 4, maybe 5 if you want to count Abernathy v. Sullivan. But he's struck out. This is the essay written by William Lee, where he goes into citizen journalism. And he talks about Glick and he talks about Glick. See, look, we're talking about Glick. There you go. There's Glick. And all these fun things. But you may notice that the public's right of access to information is coextensive with that of the press. The public's right of access to information is coextensive with that of the press. There's a distinction there. Now, this guy is not a Supreme Court. He's not the Supreme Court. He's writing an article on it. And if you read his article, essentially the argument that he's making is that if he's talking about New York Times and Abernathy, if the Supreme Court had decided Abernathy on the due process claim, it would have left people swinging in the breeze. New York Times would have been decided on First Amendment issues. Abernathy could have been decided differently on due process issues. His argument is that had they decided on due process issues, then it would have changed things. It would have made it harder for people to criticize the government. It would have exposed people, individuals, to prosecution, not prosecution necessarily, but civil liability for criticizing the government. The perils of defining journalists. He's a journalism professor. He's a professor of journalism and mass communications. And, you know, I'm not saying he's wrong. I personally think the First Amendment protects journalism, not journalists. And had a right to record argued along those lines, well, as long as he didn't just flat out drop a SCOTUS says, I probably wouldn't have had any issue with him. Because I firmly believe that the First Amendment protects journalism and not journalists. It protects recording newsworthy events, not press photographers. But that's just me. But let's continue on with the stupidity, because I like stupidity. He's got Glick v. Cunniff, where a circuit court declares such developments make it clear why the news gathering protections of the First Amendment cannot turn on professional credentials or status. Yeah, again, I agree that the First Amendment protects journalism and not journalists. But then you have to wonder why even in Glick they draw distinctions between a private individual and a reporter. Why would they draw a distinction between a private individual and a reporter if there is no distinction? It is of no significance that the present case, unlike Ayako Buchi and many of those cited above, involves a private individual and not a reporter gathering information about public officials. The First Amendment right to gather news is, as the court has often noted, not one that inures solely to the benefit of the news media. Rather, the public's right of access to information is coextensive with that of the press. There is a distinction between the people, the public, and the press. There is a distinction between people who do plumbing and plumbers. I guess that's hard to grasp, though. And finally, Akins v. Knight. Oh, Akins v. Knight. Akins v. Knight is a terrible case that was terribly decided. I've made videos on Akins v. Knight before. Akins v. Knight. Here's Akins v. Knight. The circuit court deals with mainly whether or not the judge should have recused herself. Part A is all about the judge recusing herself. And then this is part B. This is the part that addresses Akins, everything else about it. Akins also argues that the district court erred by granting the motions to dismiss and for summary judgment filed by the defendants and by denying his own motion for partial summary judgment. After careful de novo review, we conclude that the district court did not err in its thorough and well-reasoned opinions. Accordingly, we affirm. Now, I think the district court had just shoddy, terrible opinions in Akins v. Knight. I've gone over it in the past. But it doesn't say anything in here. Literally, all of this is about the motion to recuse. Akins wanted the judge to recuse herself. All of Part A is about the motion to recuse. These are the underlying facts, per curiam. Here are the facts. Here are the facts. Shortly after the lawsuit, he filed the motion. Okay. First, we consider the denial of the recusal motions, and then this is all the relevant stuff about the recusal. And then Part B is this one little tiny, I think it's just one sentence, two sentences. Two-sentence paragraph about the motion, or about the other portions. Pretty stupid. So I don't know what he thinks Akins v. Knight is going to do. But he likes to throw in nonsense. And finally, if there is no difference between people and the news media, one has to ask oneself what the Supreme Court is doing when it provides for the general public and professional journalists with information about the court and its work. The courtroom has a limited number of seats set aside exclusively for the media. And the press room has 18 carrels for the media's use. Well, I thought there was no distinction per the Supreme Court. I guess there is. To ensure efficient allocation of space and resources, the PIO has traditionally reserved hard passes for full-time professional journalists employed by a media organization that have records of substantial and original news coverage of the court and a demonstrated need for regular access to the court's press facilities. It sounds like they're drawing a distinction. This is www.supremecourt.gov/public info/press/media requirements and procedures revised 070717.pdf. To better meet those demands and the needs of journalists, the PIO adopted new requirements and procedures. To qualify for a hard pass, an applicant must demonstrate that the applicant is a full-time journalist. Okay. The applicant operates or is employed by a media organization, and the applicant's primary professional work is for the media organization through which the applicant seeks a hard pass. The applicant or the applicant's media organization has a record of substantial and original news coverage of the work of the court. Might be hard to do with a cell phone and a YouTube account. Not impossible, but it could be hard to do. The applicant will be present at the court regularly for reporting purposes. The applicant does not practice law before the court and is independent of the individuals and entities that practice law before the court. And the applicant has not been employed by the court during 2 years preceding the application for a hard pass. Day passes. To qualify for a day pass, an applicant must demonstrate the applicant is a journalist affiliated with a news organ or with a media organization, or, as space allows, a writer who is not affiliated with media organization. So you get in first if you're affiliated with a media organization, and then followed up with if space still allows a writer not affiliated. And the applicant has a need to report from the court on or to observe a particular court session. Anyway, I think that the SCOTUS doesn't disagree with Wendell Fears necessarily. Or at the very least, Right to Record has failed to provide the citations that he should have. Anyway, I guess I'm done beating up on Right to Record. Thank you very much for watching and have a great day.